get right into this thing. So here's the deal. There was a case where essentially the Social Security Administration sent out via OIG, the Office of Inspector General, a CDI Unit Investigator, aka a team of secret police officers and investigators, to go ahead and look into a particular person. This claim is Gary M. Glessing, plaintiff, against Commissioner of Social Security Administration, the defendant, 13 Civ 1254 BMC. Let's get right into it. All right, I'm going to give you some of the basic fact pattern, but before I go directly into this, I want you to remember what the Fourth Amendment puppy-roo is. It is, Fourth Amendment, the right of the people to be secure in their persons, houses, papers, origamis. The effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This was super duper important, and the reason why essentially it was passed was because people should not allow the government to have too much power. That's why we have all kinds of things. That's why we have a Second Amendment. That's why we have a First Amendment. Actually, that's why we have all the amendments. It almost always comes back to the government is too compressing in its capacity to remove a person's ability to live freely. Okay, that's what makes America so great. Although we've been ups and downs here and there, of course, it is what it is. But here we go. All right, Fourth Amendment: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, cool. Now you've got that. You understand the Fourth Amendment. You're good to go. Let's get into this real quick, which, by the way, is important because Florida just passed a new rule. I saw Governor DeSantis swiggy his signature that basically says they can no longer pull you over in your boat to just do a safety check and see what you have on it, because that is considered essentially a search, and they do not have probable cause to just randomly pull people over. You may be asking, as somebody who lives in Florida, have I ever been pulled over in my jet boat, which is not working right now. It hasn't for like 3-4 years. The correct answer is yes. It is a jet boat. It has two of, at the time, the largest jet ski engines that they made in it, although it's an old boat. It's from like 1999. And therefore, this small jet boat should have been illegal. They should have never made this thing. It is a crotch rocket. It can spin out. You can go 70-something miles per hour. It is literally the most dangerous jet boat that has ever been made legally by Yamaha, or pretty much any jet boat maker that wasn't like some guy in a garage living in Louisiana who just got curious. And as a result of that, yes, I have gotten tickets before. Believe it or not, I know. Who would have thought, right? Hey, all right, let's get back to this case. So here we go. All right. District Judge Kogan. Plaintiff brings this action pursuant to the Social Security Act, 42 U.S.C. 405G and 1383C3, seeking reversal of the commissioner's final decision that he was not entitled to Social Security benefits. Alternatively, plaintiff requests remand of this matter for further proceedings. The parties have each filed a motion for judgment on the pleadings pursuant to Rule 12C of the Federal Rules of Civil Procedure. Blah, 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 blah. Shenanigans, Pop-Tarts, yada, yada. Let's get right to it. All right, let's just scroll a little bit to the important part. I don't want to waste anybody's time here. Okay, let's get to it. Page 9. Plaintiff also answered questions about pain, stating that he suffered from left knee pain, which had gotten progressively worse. Plaintiff was not receiving medical treatment for that pain. The frequency and duration of the knee pain varied, and it was brought on by standing and walking. Sound like a classic knee pain situation. Plaintiff did not use pain medication, but took certain joint supplements. Plaintiff also relieved pain by sitting and elevating his leg. Cool. Awesome. As part of an investigation undertaken by the Cooperative Disability Investigation Unit. So just to summarize for you in case you missed it, he filed for disability benefits, got a denial, went to recon, got a denial, went to the ALJ hearing. I'm not sure exactly. Well, hold on. I can tell you, hold on. Plaintiff was observed on June 9th, 20. Actually, I can tell you. Let me look back a little bit. Hold on. Let me see some procedural background details. They might have put the dates in here. Plaintiff applied for disability insurance benefits alleging disability on June 14th, 2006. Appeals counsel denied plaintiff's request for review on February 13th, 2013. All right, and so then they did a review of him in 2011. So probably somewhere after his ALJ denial. Hold on, let me see if I can find the exact date here. I might be able to. Let's see what we got here. That's 2013, 20. What we're looking for is like a 2011 notation. Hold on. You're getting grubby with your demands. Hold on. Jeez, don't forget to like and subscribe while I'm figuring out when he was actually followed by police with them searching him around his house. Hold on. Let's see. That's 2006. Okay, here we go. Mahendra Misra, MD, conducted a consultative examination on June 9th, 2011. Let me see if that's the same time, because they usually link those two. Yeah, June 9th, 2011. They always use a tactic. They always use this tactic. I mean, I've seen it, I think, once where they didn't, but they almost always use a tactic where they will send you to their doctor, and the day you wake up to the moment you leave that doctor to all the places you go to thereafter, boy, that report has all kinds of stuff on it about that particular moment. But let's go to this real quick, okay? So Mahendra Misra, MD, conducted a consultative examination on June 9th, 2011. Plaintiff stated that he retired from his job as a police officer in May 1998. Yada, yada. Misra examined the plaintiff and found that plaintiff could heel-to-toe walk with a limping gait. Yada, yada, yada. Blah, blah, blah. Plaintiff was seen by Dr. Springer on April 16th of 2012. Okay, yada yada. But they don't give the procedural history in this as to exactly when. All right, well, we know it was somewhere around the ALJ hearing, but before a decision was made by appeals counsel. So probably what happened was he went to the ALJ hearing, might have had an approval, might not. They did a review where they sent him off for like a CDR, or there might have been a CDR that was during the hearing, because sometimes the judges will say, okay, I want to send this person off to go see if they're really that bad. So like, you go to a hearing, and essentially, to make it really simple, the judge will order you to go to a consultative examination medical expert appointment. And when they do that, sometimes, like potentially in this situation, they will request that an investigator follow you around. Let me read that part to you. As part of an investigation undertaken by the Cooperative Disability Investigation Unit, CDI Unit, of the Social Security Administration, Inspector General, plaintiff was observed on June 9th, 2011. So that's when they sent the person off to the consultative examination appointment by Ishmael Hernandez, a state investigator. Plaintiff was observed watering the lawn and doing yard work around his residence. He hopped down a step from the lawn and went into the house. None of that really seems that objectionable. You know what I mean? Like, none of these are like massive undertakings. You know what I mean? Like, oh God, he's watering the lawn, therefore he's not disabled. Oh God, he hopped, off a stair, or off a ledge. Oh, he's not disabled. None of these really seem like de facto things to claim that he's not disabled. I get if you have knee pain, you're not going to hop. I do get that. But at the same time, none of these seem like that objectionable, to the situation at hand. He hopped down a step from the lawn and went into the house. Plaintiff was later observed walking. Now, this is going to bite him. This is going to bite him in the butt. Plaintiff was later observed walking several blocks and climbing into a van and traveling to a store. Now, I bet with this whole, if you're walking several blocks, they're going to get you on that one. You know what I mean? If they're like, okay, here's video of this person going from here to there. Now, remember, there's different types of video technologies that they have available to them. They have, for example, a dual body worn camera system. They also have, for example, telephoto system. They also have basically audio systems on their body to capture audio as well. So the point that I'm getting at is like, if they want to get footage of you around the house, they can do that. Do they need probable cause for that? No. Do they need probable cause for taking footage of you inside your house through a window? Usually, yes. Are there special rules for pole cameras and, tracking features and stuff like that? Each state is a little bit different, but the bottom line is, usually they'll try to get some evidence and then turn that into a warrant with probable cause via the Fourth Amendment. And then at that point, they get access to basically being able to, film you inside your house, follow your car and use tracking devices when they're not present, when they're not physically there. So in that instance, they get to go ahead and begin the process of getting deeper and deeper. But it's a game. Remember, they start out with, let's go look at this guy. Okay. We got a little bit of questionable conduct we won't want to check into, right? So, you begin with a lesser standard of probable cause, reasonable suspicion. I'm reasonably suspicious that this disabled person might be hopping off a ledge, might be watering a lawn with those knee problems. Well, reasonably suspicious about this, right? Now they catch you walking, 3 blocks. We're starting to get to that point where we're like, hey, wait a minute. I thought this guy had a knee problem. So, all right, let's go through this. And then when they say this right here, this is important. Plaintiff was later observed walking several blocks, and several could mean 2 or 3. Some people are several's 2, some people several's 3. I hate when they use the word several. You know what I mean? Like, give me some blockage, give me some numbers, give me some footage. And was observed taking several running steps to avoid traffic while crossing the street. That's going to be a little bit of damning evidence because now they got you running a few steps. But at the same time, I don't feel like running a few steps to avoid traffic while crossing the street is de facto that you're not disabled. Like, to me, that means you chose life over death. You know what I mean? Like, you chose to survive as opposed to, you put up with the pain to jog a little bit to get out of the way of essentially traffic that could potentially end your life. To me, I don't see, and maybe I'm biased, maybe I'm biased, but I don't see OIG having power to say you're a fraudster, you're not disabled because of that. Okay. What said knee problems are his only issue? I'll actually go through the rest of them. I just wanted to cover the CDI Unit's investigation, then we'll go back to the fact pattern of the brief. So, okay, let's read this again. Plaintiff was later observed walking several blocks and climbing into a van and traveling to a store. You notice how they use the word climbing? Because the van is expected to be up, you know what I mean? High. You got to like climb into it. And I'll be fair with you. Like, I got to get into my Prius. I got to climb into my truck. You know what I mean? Like, I got to get into my Camry. I got to climb into my, in this case, his van. Now, some vans are pretty low, some vans are pretty high, but they're using the word, they're using some biasing terminology here of climbing into a van. So, in our minds, we're like, all right, he's grabbing handle 1. He's got handle 2. He's just going to pull himself up and, you know what I mean? Just climbs up into that van, because it's just, otherwise you'd never get into it. There's no way to just, turn around and sit down. None of that. No. You got to Mount Everest this shit. All right, so climbs into a van and traveling to a store. He drove to a nearby store and was observed taking several running steps to avoid traffic while crossing the street. I still feel like I don't feel like they have what they need. Like, walking 3 blocks. If you walk 2 blocks with a knee problem, I still don't see. I still see them as disabled. I still see if you walk 3 blocks, 4 blocks, then we're getting a little iffy there. Now, real quick, I want to do a shout out to Greg Yergin. I super appreciate the $2 donation. That's absolutely awesome. Let me put a little heart on there. Very, very cool. Love the cowboy hat. I want to get one. They don't look good on me. Otherwise, I would literally get one since I work on a farm. Anyways, do any of you guys know which brands to look at for cowboy hats? I don't know anything about it. I have 2 issues, hair loss and a lack of cowboy hat. I feel like one might fix the other. I'm not sure yet. We're going to find out. Princess Diana, royalty for the YouTube channel, $2 donation. Let me give a little like and a little happy star there, a little thumbs up. Howdy, Walter. Having a nice weekend. I'm having a burnt to hell weekend because I had to dig some holes for some stuff. And I had an auger and the auger broke. And I had another auger. That auger broke. It actually wouldn't even start. So technically, we never even got to working on that other one. So anyways, point is, if I look a little miserable, it's because I've been digging holes. And has anybody ever noticed that our system by which we hand dig a hole with those, like, you know what I mean? Those hole diggers where you got to like shove it into the ground and goop it and then pull it out and chuck it over there. Have any of you guys ever like wondered how we did not invent a hand version of that that's better than that? I mean, it is just, and then you hit a stone and there's no way around it. You have to like get a giant metal rod, beat it with a hammer, and then you got to like and just put, you know what I mean? It's just, we can do better, people. We can invent something. All right, let's get off that. The investigator noted that plaintiff walked at times with a slight limp, but used no assistive device, and it appeared to lead and appeared to lead with his left leg while climbing without difficulty. Again, we're climbing again into the van's higher than average cab. Okay, so you can see how they kind of bias this shit when they write the reports, and this is the brief. This is the district. I'm pretty. Yeah. This is hold on. This is United States District Court, Eastern District of New York. This is Brian M. Cogan, the judge. The brief was well written. Honestly, it's not. He did a good job. It's just I feel like these CDI units are. I don't know. Let me read you the whole section so you get the whole schmutz all in one. No flavor, no spin, no Gatorade on this. I'm giving you. Just water. If you feel any electrolytes, that's you. You're the none at all. Now let's get into it. As part of the investigation undertaken by the Cooperative Disability Investigation Unit of the Social Security Administration, Inspector General, plaintiff was observed on June 9, 2011 by Ishmael Hernandez, a state investigator. Plaintiff was observed watering the lawn and doing yard work around his residence. He hopped down a step from the lawn and went into the house. Plaintiff was later observed walking several blocks and climbing into a van and traveling to a store. He drove to a nearby store and was observed taking several running steps to avoid traffic while crossing the street. The investigator noted that the plaintiff walked at times with a slight limp, but used no such device and appeared to leave with his left leg while climbing without difficulty into the van's higher than average cab. I don't know. To me, that was like. Now, granted, later on in this, the judge says the CDI Unit Investigation report, the ROI, wasn't like the thing that he used to decide you get benefits, you don't get benefits. But still, like I see a lot of this stuff from these CDI investigation units where it's, I don't know. I just and it's this kind of shit, where it's and appeared to lead with his left leg while climbing without difficulty into the van's higher than average cab. I don't know. I don't see that as all right. Let's go back to basically, the fact pattern stuff, so you understand exactly kind of what's going on here. Hold on, let me skip through a bunch of this. Yada yada here on the history, because this thing goes back to 95 and cha. Let me just get you the most there's got to be a thing here. Hold on. No, it goes back to 19. Yeah, okay, gotcha. Let me find you the exact thing here. All right, come on. Medical evidence submitted to the bills. Okay, all right, here we go. Plaintiff was seen by Dr. Springer on April 16, 2012, once more complaining of recurring pain, mostly on the side of his left knee. Dr. Springer initial examination revealed a stable knee with some tenderness. There was a mild quadriceps atrophy. Dr. Springer initially recommended physical therapy, but on May 14, 2012, Dr. Springer suggested arthroscopic surgical exploration of the left knee. The surgery was conducted on May 25, 2012. Dr. Springer found recurrent tears of both medial and lateral meniscus in grade 3 and grade 4 issues. Dr. Springer noted that the ACL reconstruction had healed to the posterior cruciate ligament and still gave decent stability. I got to print this thing out with bigger font because my eyes are crap at this point. Dr. Springer suggested an aggressive course of physical therapy. Dr. Springer opined that plaintiff's case represented the gradual deterioration over the years from his original surgery through 2012 with the worsening condition of plaintiff's knee. Dr. Springer stated that, based on his observations of plaintiff's knee, his medical opinion was that plaintiff's current conditions of grade 3 and grade 4 issues with his knee would already have been significantly progressed by January 2011. Non-medical facts. Plaintiff was born in 1963, obtained a general equivalency diploma, and attended the police academy. Police worked as an NYPD officer from 1984 until 1998. From October 2001 to June 2006, he worked as a security guard at the museum. Plaintiff stated in his function report that he lived with his family, including his wife and 3 children. Plaintiff was able to go out unaccompanied and shop for necessities in stores. He was able to perform chores that he could modify to offset his physical deficiencies, although the chores take longer and require periods of rest, and he might require assistance. Plaintiff stated he was unable to walk effectively or lift moderate to heavy objects while standing. He needed to rely upon support for balance when rising from a sitting position. Plaintiff found climbing stairs challenging, but could do so at a slow pace, and with assist of a guardrail, descending stairs was more difficult. Plaintiff could not kneel comfortably and bear weight on his left knee. Plaintiff also answered questions about pain, stating that he suffered from left knee pain, which had gotten progressively worse. Plaintiff was not receiving medical treatment for the pain. The frequency and duration of the knee pain varied, and it was brought on by standing and walking. Plaintiff did not use pain medication, but took certain joint supplements. Plaintiff also relieved pain by sitting and elevating his left leg. All right. Can we just be very straightforward about this? First of all, this is a 2011, 2012, 2013 situation. People found disabled in that time period or earlier didn't really need to be that disabled. Okay. A lot of the people found disabled back then would immediately be denied nowadays. Like the medical conditions required nowadays are far more severe. Like you don't have to be bedbound, right? But if like there was like a notch down where you're like have to use ambulatory devices to walk a distance and the distance isn't even that far. That's what we're talking about here. This guy was obviously nowhere even close to that. Nowhere close to that severity. This whole situation is in like the mild, moderate, maybe moderate for some things. Maybe eke out one category, moderate severe on an RFC analysis. But again, back then, people could be found disabled for significantly less impairments. Let's just, and that was a trick. Like back then, people, what they would do, just so that you're aware, is, they go in for a couple medical appointments and say they have anxiety, and then boom, they were getting a check. And it was just a different time. Now, remember, 2012, that 2013, that's kind of the ending of the golden year of being found disabled. Anything after that, and it gets much, much harder over a period of time, especially in 2017 forward, to be found disabled. So when people are like, yeah, I was found disabled 20 years ago, and I'm like, okay, well, where are you at now? Because, the where you were back then, you're super easy to be found disabled. Especially, as Social Security benefits, the civilian benefits were way easier to be found disabled than the veteran benefits. Now it's switched. Now it's much easier for a veteran to get 100% PNT than it is for civilian benefits. There was a massive switch. So it's an interesting thing. Cyber Katie, I love that name. That's super cool. Cyber Katie, love the little anime picture there. It's awesome. Did a $9.99 donation. Let me put a little heart on that. That's awesome. Let me check that out. Really appreciate you. I'll email you soon. Thank you for all that you do. Super appreciate it. Thank you. That's absolutely awesome. So from my perspective with this case, with this brief, okay, my feeling about it is that the CDI unit was ordered to follow this person around. The person was not really that bad. He probably already had pensions from his police work. Might have had other pensions too. So when he stopped working, he was probably riding the pension train. And that's a red blinking light to these judges when they see that. So when they see that red blinking light of a veteran pension, a police pension, a firefighter pension, a special executive pension, a mega corporation pension, a union pension, or whatever pension, when they see that and the person goes from like working all the time to boop pension, that is on par with the red blinking light of, for example, somebody having kids. And now, they've had kids, they've stopped working, and it's like a year after they've had kids, and boop, they're applying for disability benefits right there. And that then, the judges are like, okay, that's a mom that's just trying to hang out with her kids and raise her kids. And I'll be very fair with you. I have had judges who are, in particular, are females who will specifically ask about the ages of their children, because that tells us two things. It tells us more than that. But number one, it tells us when that person was able to do the act that makes babies, which, to be fair, for a lot of disabled people, if you got back problems, knee problems, hip problems, that might be a little problematic. I will never forget the day I had a claimant trying to sell me on the idea of representing them, where they said to me, well, I don't have to actually do anything. I just lay there. And I had to use every ounce of my strength, of my honorable muscles, to not laugh as hard as I could, because she was serious, completely and utterly serious. And I was just like, well, and I remember how I responded to that. I said, well, that is true. You know, one party can just kind of chill out for that, part of it. But then to be fair, the having of the children for people who have hip problems, back problems, stuff like that can be catastrophic for a disabled person. So, you know what I mean? I'm just trying to explain where the judges are coming from with this. When the judge sees like a new mom and the new mom just began filing for disability benefits, it's kind of like this. Oh, he just stepped down from his position as a police officer? Oh, okay. What pension recently, timed in so that now you can get your pension? It's the same thing. There's certain red lights that these judges look for that are bam right there. So, okay, what's my point here? What's my point with this whole thing? Okay. I just saw the comment from what with the question mark where he mentioned the cowgirl. That is correct. I'm not even going to go into that, but the point is you are correct. And that's the thing with the new mom situation with these judges, and they get now to that point. I've had female judges that will go after women. I don't know what the thing is, but women don't always support women. It's maybe a competitive thing. I don't know. Guys don't have that same thing. We're just trying to jump a monster truck over another monster truck. And if we make it cool, if we don't, we have a celebration of life. That's what we're trying to do. But women, much more competition. It's two monster trucks that you got to get over. The point is, okay, there will be female judges where I've literally asked the question to prove that it was not just about when the kids were born, because the kids were like 5 and 6. And I said, okay, such and such, Mrs. Smith, walk me through what are the current ages of your children. And I've had the judge, and this is where you get into like advocate judges that are like advocates on behalf of women. There's not a lot of them, but they do pop up. Where she jumped in and said, "I don't see how that question is relevant, counselor." And that's when I knew I had a judge that was supportive of this claimant because she was a female. And I immediately said, okay, no worries, Your Honor, I'll go to the next question. And then I just da 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 da. But you have to be quick during the hearings. But the point is, now you have all the information. You have the CDI unit investigation. You have the notes related to it. Now let me read to you again what the CDI unit report found. He's got the knee problems with his left knee. He's gone through some surgery. He's gone through multiple issues. He's got a meniscus problem, blah, 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 all that stuff. Okay. It's 2012 and getting disability benefits was way easier back then. Way easier. All right, here we go. All right. Tenebriness. Does this tie into the cowboy hat? I hope so. I hope somebody just gives me like a little. Sometimes you guys give me really good comments and you'll be like, this is how you fight hair loss. Blah, 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 blah. And I read it. I do read those. Hopefully I'll get one of those on cowboy hats. All right, let's get into this. Let's read it one more time. As part of an investigation undertaken by the Cooperative Disability Investigation Unit of the Social Security Administration, Inspector General. So remember, the SSA has a special group called OIG. OIG is the Office of Inspector General, who then works with DDS and CDI units. DDS and also OHO, they adjudicate claims to see if you're disabled. Whereas the CDI units have a bunch of police officers and sheriffs that go and investigate you and create what's called an ROI, which is a report that shows that you either are or are not disabled. But that report doesn't de facto dictate if you're going to lose your benefits, although they obviously use them for the purpose of reviewing for fraud or similar fault. Cool, you're good now. All right. Plaintiff was observed on June 9th, 2011 by Ishmael Hernandez, a state investigator. Plaintiff was observed watering the lawn. Again, I don't feel like watering the lawn, to be fair, is something that it's just, to me, and the investigators outside the house, they've got a camera on you. They're watching you, leave your house, do things around your house. I just don't feel like watering the lawn is enough to say that somebody is not disabled. I feel like, sure, if they're bedbound and they're watering the lawn, okay, fine. If they are unable to interact with people and they get a video of you talking with 3 neighbors that go by, okay, fine. If you have a back issue, I don't see watering the lawn. And maybe I'm wrong, because then you got to pull the hose out, blah, blah, blah. I just don't see that I see that as therapeutic. Like you would, for a lot of guys, and maybe women. I don't know. I'd have to do a survey. But for a lot of guys, mowing the lawn and watering the lawn is like super therapy. It's therapeutic. I mean, it's like going on a pumpkin patch trip and just, mowing through those pumpkins with a big old mower and watching them shoot out the side of the tractor. That to me is therapeutic. It's frightening to most, but that to me is therapeutic. All right, so let's keep reading. Plaintiff was observed watering the lawn and doing yard work around his residence. Now, the yard work, that could bite you in the butt, because if we're talking about digging holes, God, thank God we have. Now I can tie it back together with, you know what I mean, the hole digger. Thank God we had that one. So in doing yard work around his residence, yeah, they're gonna burn you on the stick with that one. Yeah, they're gonna do that because, look, when you're out there working and throwing some screws into the house, pulling up some boards, maybe pulling out weeds, digging holes to put a pole in, they're gonna get you on that one. He hopped down a step from the lawn and went into the house. Now, it's like, you go into the house, they don't use a lot of conversation after that because then you're in your house. Then they got to have their PC, the probable cause to start working it. Plaintiff was later observed walking several blocks and climbing into a van and traveling to a store. He drove to a nearby store and was observed. Now, you notice when they said there, plaintiff was later observed walking. That means later in the day, usually. Observed walking and climbing into a van and traveling to a store. He drove to a nearby store and was observed taking several running steps to avoid traffic while crossing the street. The investigator noted that plaintiff walked at times with a slight limp but used no assistive device and appeared to lead with his left leg because he's got left leg problems. You normally lead with the other leg without difficulty into the van's higher than average cab. All right. This was all either probably done on the same day or a second day after the CDR or before the CDR where they send you to the medical appointment. So this is very, very, very interesting stuff. Now, remember, most of these CDI reviews, they take about 2 weeks to watch you. If they don't find the stuff that they want within 2 weeks or a lesser period, they're moving on. They're making the report. They don't have time. So it's usually a very short period. And the thing they usually tie it to, the like one-day event thing, is they send you to their doctor. And when they send you to their doctor, they're looking at, they're up early. They're waiting for you to come out of that house, grab your morning paper, jump down the steps and grab it, bring it in, take your dog for a walk, yada, yada. They're doing that stuff, Now, look, I'm going to tell you something that is important for you to understand. If you live in a community where you are the last road to going nowhere else, okay? So you get to a cul-de-sac, you go down, right? And you get to the final road and you're on the final road and it goes nowhere else. Then you are going to be very aware of the cars that are on that road and who parks and who doesn't park. You're going to know. If you live in the country on a mountain and the road winds around the mountain or drives directly up the mountain, you are going to be very aware. When somebody is watching you from a car, you're going to be very aware. Those people tend to be more protected than, for example, somebody who's got a house on a main road. Somebody's got a house on a main road. You're not going to know the cars. You're not going to see them, you're not going to really know what's going on when they're filming you, all that stuff. So the point is, when the investigation vehicle, the investigative van, the filming van shows up, you're going to have a better shot at knowing what's going on if basically you live in an area where everybody knows each other and nobody can get there without being in a spot that would make them seem different than what's normally there. So in that regard, they have an advantage for the people that live on top of a hill or a mountain. However, there are some times, and you read reports specifically from, some of the files released, they have a telephoto camera system and they just go to some other bluff hill mountain and they just shoot it across the way and look straight at your house. So you got to watch out for that stuff. But if you live in a highly wooded area, guess what? They're not going to get a clear shot. Remember, they still have to be able to use this evidence in case you sue it, take it higher up and then say, that's not me. Because if they present evidence claiming that that's you and they don't have a really good shot, that's a problem. Okay. All right. Now, we have gone through what they basically did in this claim. It goes on quite a bit, but doesn't talk much more about the CDI Unit Investigator. So, summary time. What did you learn? You learn that they park outside your house. You learn that they usually park outside your house on the day that they have a consultative examination medical expert appointment. You learn that they follow you from the morning through the rest of the day. You learn that they take video of you. You learn that they have backup video systems. You learn that they don't really take much video of you in your house or talk about what you're doing in your house because of, you guessed it, the Fourth Amendment does not like it. You learn that the Fourth Amendment protects you because they have to have what's called probable cause to seek a warrant. When they get a warrant, they get more access. So the game that they use is a stepping stone game. If they have some evidence here, they can usually try and get some more evidence. And once they build that evidence up from reasonable suspicion up to probable cause, then they got what they need. They can go get a warrant from a judge and they can start getting better evidence against you. Now, some of you are probably sitting there saying, oh crap, I leave my house sometimes as a disabled person. Remember, the specificity in this brief about the particular impairments that this person has. So let me give you some basic examples. If you have a respiratory issue and they catch you jogging, that's a problem. If you have a bipolar issue or a interaction with other people issue and they catch you chatting it up with a bunch of neighbors, that's a problem. If you have, for example, a hip issue or a knee issue and they catch you running or they catch you jogging or lifting weights or lifting things that are heavy or walking multiple blocks, that tends to be a problem. If they catch you, for example, let's do this. Let's say that you, for example, have a cardio issue, right? And they catch you climbing up multiple stairs at an apartment complex. They got you. All right. So these are the things that you need to keep in mind going forward. Okay. That's how this stuff works. Now, please remember, Attorney Walter Hnot, please remember to like and subscribe. We don't have as many likes in here. We need to like that like button. We need to care for the like button. We need to talk nice to the like button. Give it a little tap and say how we doing there. All right. Other thing, if you get a chance, head over to disability. Oh, I hit the Levo. I'm not sure what it is. Doesn't matter. There we go. Head over to Disability Resolution Law Firm or Disability Resolution Florida on Google. Throw some stars up there if you want. You get to decide how many, but I love seeing those when I wake up. With that said, I go live usually on Mondays and Thursdays. Obviously, I had coronavirus about a week ago, so that kind of screwed things up for a bit. But I am starting to feel better, so expect me this Monday to go live and basically go ahead and answer questions for free about disability law. I am America's most viewed and subscribed to and clicked on disability attorney. Although right now I look like I'm schlumming because I'm just tired. It's Sunday. Technically, it's my birthday weekend, and I'm tired. It just is what it is. Anyways, I will catch you all a little bit later. Please remember, Mondays, Thursdays, I go live. And then there's a mini contract. If you need a private consultation to run a situation by me, you get a 1 hour. I will catch you all later. We have another video in about, I would say, realistically, 10 minutes. We'll be starting. I'm going to go eat some food, get jazzed up, drink some special tea with some caffeine in it, and we will be rocking and ready to go. I'll catch you soon, and we'll go from there. Attorney Walter Hnot, thank you so much. Bye-bye, everybody. Bye-bye.